civil rights litigation. Basically, anytime your rights are violated by someone operating under color of law. That means someone who's operating, a police officer in uniform, a police officer, off duty if they're enforcing the law. Right? It's a little tricky. We're talking about that a little bit. Any type of state or local law enforcement agency, federal law, even though it's a little tricky. We'll talk about that too. So
even like military police and stuff like that. Or
no.
Okay. So it's at a state level?
State and federal level technically.
Okay.
So with military police, you could say if they're operating under color of law, military police don't really operate with citizens normally. So you're not going to get a lot of military police cases. But there's a different set of laws for federal law enforcement officers, a different set of laws for state and local law enforcement officers. Okay. And the Supreme Court has made that big distinction. And basically, the practical application is that, I can't really take any federal law enforcement cases because they destroyed the law on that one.
Right.
They destroyed the law, federal law enforcement. Okay. So if you get hit by the FBI,
don't holler at me. I help you make things.
Enjoy the ride.
It's wild. Right. I wish there was something I could do, but the law, they just destroyed the law. That was a couple years ago, so they don't need to be paying attention. But a couple years ago, they destroyed the law. So basically, they make it so difficult.
All right.
Yeah, and so basically.
So let's start with just lay out the common type of things that you're gonna put in your complaint. You're accusing them of police brutality, wrongful arrest. Like what are the claims?
The base is going to be false arrest, which means that you were arrested, you were detained in police custody, and false arrest goes from the time you're in handcuffs or not free to leave, depending on how the officer conducted himself, and then up to when you see the judge. So let me say this again: false arrest is up to when you see the judge.
Okay.
After you see the judge, it's called malicious prosecution.
Oh, okay.
All right, and malicious prosecution is a different standard than false arrest. So if you get arrested, say you spent 2 weeks in jail, that first 24 hours or 48 hours until you saw the judge is a false arrest claim. The rest of that time, from that 48 hours to the 2 weeks, is going to be a malicious prosecution claim. And those are two separate claims, right? Okay. Now, you have another claim that you have a lot, obviously, is excessive force, right? And that's just in New York, the state law claim was assault and battery. In federal law, it's excessive force, so that means obviously an officer did not use reasonable force to subdue you. Now again, under certain circumstances, an officer is able to use force. It's really analyzed pursuant to the facts of the incident, so it's really case specific. But if an officer uses excessive force, then generally that you can do a claim for that. There's another claim called failure to intervene, which means that if an officer is seen a constitutional violation, they have a duty to intervene to stop it, and of course, they never do.
Right. I would imagine they never do.
Yeah. So
that blue line is thick.
So you can bring a claim because the other officers were standing around and watching while they beat the ass. And then there's some due process claims. Just quick rundown, a couple of them. A cop fabricates evidence, he lies about something, forcing to the DA in trouble. Brady, he knows, this. If I get this fact out, he didn't do the crime. Someone told me that he wasn't even there. I don't forward that to the district attorney. I just keep that secret. You can get him for a Brady violation. Okay. And those are the two main due process violations. There's a couple of other ones.
Planting evidence falls under those two? Because I've seen
planting evidence.
Planting evidence.
That would be fabrication.
Okay.
You're fabricating evidence. You're putting something there that wasn't there. So you're lying, and you forward that lie to the district attorney, or the district attorney finds out about the lie and uses it. I'm adding that last part because it's important because the district attorney has to find out about this and know about this in order for it to be a violation. If you violate it and then you never finds out and it has no impact on your prosecution, they're probably not gonna, it's probably not gonna be a claim.
Okay.
Now, these cases, they all start post resolution of a criminal case.
They can and they can't. So generally they're going to. I'm just gonna be honest. They're going to. But the thing about false arrest claims is that it doesn't matter whether you committed the crime with false arrest claims. And so you could even though lawyers are going to take the case, I don't want to get you the wrong case, but you could technically be convicted of a crime and still have a false arrest claim. Because the only thing that matters with false arrest is what the officer knew at the time of your arrest. If the officer did not have enough information for it to be probable cause, then that means that you have a claim. Ultimately,
you're the one who did it.
He found enough information later.
Like the cop
so that's interesting. So then, like, so the legality of the arrest always comes up at a suppression hearing on the criminal side.
Yeah.
If a client wins their suppression, meaning there was something illegal about the circumstances of the search, which kind of nullifies the arrest, right? Because if you illegally got probable cause through an illegal search, would that equate to a false arrest then?
That's a great question. So when you're talking about the fruit of the poisonous tree doctrine, right?
Yes.
And that means that if you do an illegal search, anything that's recovered pursuant to that search has to be suppressed, right? Because the search is poison, and that's fruit of the poisonous tree. But this is a big distinction, right? Federal law, it doesn't matter. State law, it does.
Okay.
So under federal law, the Supreme Court said, look, we don't care about all this, whether the search was bad. We don't care about anything like that. The only thing we care about was you had the drugs on you. Right. So if you had the drugs, you got no civil rights claim. Doesn't matter if the search was bad or anything like that. Now, in New York State, it does matter. So in New York State, if you want to say, hey, look, it was a bad search, therefore they have probable cause for arrest, state will say, okay, you can have that claim. And I know someone recently, a friend of mine, he got $300,000 settlement on a case that's dead on arrival in federal court, right? Because he was able to do the state court claims.